From the KPFK studios in Southern California,
it's the Ralph Nader Radio Hour.
Stand up, you've been sitting way too long.
Welcome to the Ralph Nader Radio Hour. My name is Steve Scrovan, along with my erstwhile co-host, David Feldman. Welcome back, David. We missed you last week.
Thank you. I don't know what erstwhile means, but I'll take it as a compliment.
It means you're back, baby.
Oh, okay.
And, of course, the man who's always here. There's no show without him. The man of the hour, Ralph Nader. Hello, Ralph.
Hello, everybody.
We have an interesting show today, probably something you didn't know about. I certainly didn't know about it until I started researching this week's show, that the 1st of May, which happened this past week, tends to be a day of celebration around the world. That generally, at least in the Northern Hemisphere, marks a celebration of springtime fertility. It's also International Workers' Day. And since 1958, and this is the part I didn't know, every May 1st has been officially celebrated as Law Day. When President Eisenhower declared the first Law Day back then, he said, quote, "In a very real sense, the world no longer has a choice between force and law. If civilization is to survive, it must choose the rule of law," unquote. Now, regular listeners to this program know how much Ralph emphasizes the bedrock constitutional right for ordinary citizens to have their day in court, and how that right is continually under attack, usually in an effort to preserve the profit margins of large corporations. So a law day is sort of a day of education, and every year the American Bar Association declares a theme. This year the theme is separation of powers and how fundamental that is to our system of government. As we all know, understanding the separation of powers has become even more important considering the current occupant of the White House and his, let's just say, antipathy for judges who dare rule against him. So in recognizing Law Day 2018, we here on the Ralph Nader Radio Hour are going to welcome 3 prominent trial attorneys and talk about everything you need to know about lawyers, law firms, and civil justice. We're going to be talking to Richard Newman, who is a close associate of Ralph's as the executive director of the American Museum of Tort Law, an institution you may have heard mentioned on the show once or twice. We're also going to talk to 2 super lawyers, men who have won hundreds of millions of dollars in jury verdicts for their clients. They are Sussman and Shanin Specter. Going through their resumes, David, these are 2 guys you want on your side in times of trouble. I don't know if they did divorce work, but pretty impressive. As usual, we will check in with our corporate crime reporter, Russell Mokhyber, for his latest report from the belly of the beast. And if we have time at the end of the show, we will try to knock out a listener question or 2. So that's what we have planned for Law Day 2018. Without any further ado, David, let's call this court to order and introduce our first guest.
I'm thinking of getting married again just to hire these guys. Richard Newman is the executive director of the American Museum of Tort Law. He is a consumer attorney who practiced trial law with the firm of Edelman, Hirsch, and Newman in Connecticut. He is co-author of the treatise Tort Remedies in Connecticut and served as president of the Connecticut Trial Lawyers Association. Welcome back to the Ralph Nader Radio Hour, Richard Newman.
Thank you. It's a pleasure being here with you all.
Indeed, let's tell our listeners a little bit about the only law museum of any kind in the world, Rick Newman, the American Museum of Tort Law in scenic Litchfield County, Winsted, Connecticut. And what has been your experience? Because you have toured several thousand people through this museum since it opened in September 2015 to wide mass media coverage, domestic and international, I might add. And you've toured them, so you've looked at their reactions, you've conversed with them. Give us an idea of what kind of experience has been for these people. What did they come to the museum thinking, and what did they leave the museum thinking?
The word that comes to mind is transformative. This is a unique and wonderful institution. The old maxim was that ignorance of the law is no excuse, but the reality is we keep American citizens in ignorance of the law. And this museum aims to change all that by offering public education about the twin pillars of trial by jury and tort law. And the challenge, of course, was how do you make the law intelligible and understandable and accessible to lay people? So Eisterhold Associates designed a museum that's fun, informative, graphic, exciting. And the people that come through, we give tours from middle school kids, high school kids, college kids, law students, all the way up to senior citizen groups. And it really is transformative. They come in without a good understanding of either trial by jury in a civil context or tort law. People don't even know what tort law is or means, and yet they all are affected by it and all benefit from it. So it's an opportunity to educate them about the constitutional and historic roots of trial by jury and the importance of tort law in protecting all of us.
What is tort law?
Tort law is the law of wrongful injuries, and it's the law that lets anybody who has been harmed, either in their person or their property, their reputation, their finances, hold the wrongdoer accountable. You can hire a lawyer on a contingent fee, meaning you don't have to pay him out of your pocket. He's only or she's only paid out of the money that they recover. And you can take on the most powerful wrongdoers in the world, corporations, governments in some circumstances, bad drivers, bad doctors, unsafe hospitals, whatever it might be. This is the mechanism that lets wrongfully injured individuals be on an even playing field against the bad guys.
Wrongful injuries, starting with bullying, street crime, all the way up to the crimes of drug companies, oil companies, auto companies, other manufacturers, mining companies, hospitals, as you put it. So you're touring them through this museum full of graphic pictures of the great cases in the history of American tort law. And what do you tell them? And how do you actually tour them through this history, this storied history of American justice, going back to the founding fathers and even before that?
Well, yeah, it's very interesting. Tort law has its roots almost 1,000 years ago, back in a time when there were knights in armor and disputes were settled with battle axes and broadswords. And the English, to their credit, came up with the jury system, which was regular people, common people, deciding truth, falsehood, right and wrong. Not law being imposed from the king or the parliaments from the top down, but law instead growing up from the common people and our community sense of what's right and wrong and fair and unfair. And so the power of a jury trial is immense. It decentralizes power. It's largely uncorruptible, and it rests with the common people. So the Founding Fathers, when they wrote the Bill of Rights, we learned this from Professor Akil Amar when he came and spoke at the museum. The most common word in the Bill of Rights, other than a and the, is jury. That's how much importance the Founding Fathers placed on juries. It's in a grand jury for a criminal indictment. There's a right to a jury in a criminal case, and there's a right to a jury trial in a civil case. Jury trials are an important, critical pillar of preserving our democracy.
Yeah, we're going to talk more of that later in the program. Rick Newman, we're talking to Rick Newman, Executive Director of the American Museum of Tort Law. But this system of tort law, which is to be used by the wrongfully injured victim, they don't have to ask permission. That's why we call tort law private law. It's a private tool to hold wrongdoers accountable for damages. And by the way, it also produces deterrence and disclosure of important information about unsafe medicines, defective cars, flammable fabrics, dangerous toys, even, you name it. But tell us, what's the nature of the attack on tort law over the last few decades by the insurance companies and what I call the tortfeasors lobby in Washington and Hartford and elsewhere?
The attack has, I think, had three major prongs to it. The first, and I think the most pernicious, has been this war of psychology. It's been an effort to undermine people's faith in lawyers and courts and torts. People come into the museum and they are quick to toss around the phrase frivolous lawsuits, for instance. But then when you ask them, what are the frivolous lawsuits, they can't name any. And yet their faith in the system has been undermined by that little phrase, which doesn't really hold up very well. When you analyze how the system works, there are a million ways to weed out frivolous cases. They never go to trial. The other attacks have been access to courts with mandatory arbitration clauses where people give up their right to go to court, and then attacks within the tort system, things like caps on damages, where the power of a jury to do justice is limited. Their hands are tied by a group of legislators in a far-off state capital who think they know one-size-fits-all justice better than jurors who've actually heard the evidence in a given case. It's been an ongoing fight for decades, and it's a real struggle.
Well, tell us more specifically what plans we all have, Rick Newman, for the Tort Museum and the outreach throughout the country.
The American Museum of Tort Law, here's my little self-promoting commercial, is really a national educational institution aimed at public education about the benefits of trial by jury and tort law. And to that end, we're doing several things. Number one, we're working on our Jurors of the Future project, which is going to let high school kids around the country have an opportunity to visit the museum either in person or on videos on our website, www.tortmuseum.org, and then actually deliberate a given case. So they will serve as jurors and learn about how the law works and what their civic responsibilities are. In addition to that, we're going to try to do traveling exhibits so we can take the museum around the country. In addition to its headquarters here in Connecticut, we'll be able to go from city to city, town to town, and let people actually walk through the exhibits, see what this is all about, and learn how the law benefits them. And then ultimately, we would like to expand here and make this even a bigger museum, because museum is a little bit misleading. Museum may make you think that this is about historic events. Not so. It incorporates historic events, but tort law is still alive, still growing, still changing. There are still important, significant new cases coming down the pike, and we want to be able to incorporate those as we go.
Indeed, the evolving nature of the common law of torts, case by case, they're coming up to challenges like how do you deal with nanotechnology, biotechnology, artificial intelligence, driverless automobiles, new kinds of chemicals, cosmetics that are almost like drugs, new kinds of pharmaceuticals, the additives in the food, the possibility of pollution contaminating drinking water. So this is a lot to make our society safer and more healthful. And the Tort Museum has a lot of examples of where things have become much safer because one case brought by one plaintiff, pursued by one contingent fee lawyer, had that kind of leverage throughout the country. Rick Newman, before we go on to interview some of these major lawyers on the program, why don't you inform our listeners, how do they get tours of the museum?
Well, you can either go online at our website, and once again, that's www.tortmuseum.org, or call the museum, and we will be glad to schedule a tour. And the telephone number for the museum is 860-379-0505.
I might say to the listeners also that prominent judges, law professors have visited the museum. People from all over the world have come because we have the most advanced wrongful injury law in the world, and the museum can prove that. And just not long ago, Supreme Court Justice Stephen Breyer visited the museum, and after he went through the exhibits, he was pretty meticulous. He called the American Museum of Tort Law, quote, an excellent educational institution, end quote. So with that, Rick Newman, let's turn our attention to the Civil Jury Project at NYU, a really groundbreaking project that was established by Steve Sussman, a Texas trial lawyer.
He is a remarkable figure, and it'll be interesting to talk to him.
We have been speaking to Richard Newman, Executive Director of the American Museum of Tort Law, which we always link to at ralphnaderradio.com. And Mr. Newman is going to stick around with us after the break to help us interview our next guest. But now we're going to take that short break and check in with our corporate crime reporter, Russell Mokhiber. When we come back, Ralph and Richard Newman are going to talk to two of the best trial attorneys in the world. You're listening to the Ralph Nader Radio Hour here on Law Day. Back after this.
From the National Press Building in Washington, D.C., this is your Corporate Crime Reporter Morning Minute for Wednesday, May 2, 2018. I'm Russell Mokhiber. A North Carolina jury awarded plaintiffs damages of more than $50 million in the first of 26 cases filed by neighbors of hog farms against Murphy Brown, a subsidiary of the Chinese-owned global corporation Smithfield Foods. In the trial, 10 plaintiffs from Bladen County, North Carolina, argued that a large-scale hog operation's inadequate waste management practices had a detrimental effect on their property values and health, and that the corporate owners knew of the problems that the open-air sewage pits used to store hog waste had caused in the surrounding area. Duke University professor Michelle Nolan, supervising attorney for the Environmental Law and Policy Clinic, said the landmark verdict proves once and for all that cheap meat is a myth. For the Corporate Crime Reporter, I'm Russell Mokhiber.
Thank you, Russell. We are celebrating Law Day here at the Ralph Nader Radio Hour, an unsung but official celebration of the rule of law in the United States that's been recognized since 1958. And our next guest is here to talk to us about, among other things, the Civil Jury Project at NYU. David, introduce our next guest.
Recognized as one of the most successful plaintiffs' attorneys in the United States, Stephen Sussman has throughout his career represented both plaintiffs and defendants, ranging from Northrop in its suit against McDonnell Douglas over the F-18 jet fighter, House Speaker Jim Wright in his ethics battle, the Hunt brothers in the largest lending liability case in history, and the state of Arkansas in a milk price-fixing case. He has been widely recognized as one of the most successful litigators in the world. Welcome to the Ralph Nader Radio Hour, Stephen Sussman. Richard?
Hey, Steve, how are you?
I'm doing fine, thank you.
Good. It's been a while since we've chatted, so I'd like to have you bring us up to date on the Civil Jury Project. Tell us what that is and how it got started and why you're involved with it.
The Civil Jury Project was started 3 years ago as the only academic center in the country, in any law school in the country or anywhere, that is specifically devoted to asking the question, why are civil jury trials disappearing in this country? 2, do we care about it? And 3, if so, what can be done about it? Those are the 3 questions that we are focusing on. And it's operated at NYU Law School. I'm the executive director and spending about half my time going around the country talking to judges. It turns out that our primary audience has been judges. The reason I wanted to create and be involved in the Civil Jury Project was that for over 50 years I've been trying lawsuits, but in fact there's very little left to try in this country, either to a jury or otherwise in a public trial. And I thought then, why is that the case?
Yes.
Well, there's dozens of reasons why it's the case. Just to give you a historical background, in 1962, the average federal judge in this country was trying about 15 jury trials a year, and last year it was under 2 on average, meaning there, of the 670 federal district trial judges in this country, many were not trying any civil cases. And the truth of the matter is that the decline in trials has been even more dramatic in bench trials. So why is this public dispute resolution disappearing? One reason is that the Congress, the lawmakers in this country, beginning about 38 years ago in 1980, decided that all lawsuits were frivolous, that we were having a litigation explosion, and you need to cut out the causes of action. So we had tort reform, antitrust reform, class action reform, securities law reform, medical mal reform, caps, you name it, every device known to man to reduce the number of causes of action that could be asserted by an injured party. That was one prong of the attack. And the other prong was, even where there is a viable cause of action that can be brought to court, let's make it tough for them to go to trial. So that only the worst of the worst wrongdoings, or let's say the best of the best cases, even gets to trial. And so there are all kinds of roadblocks put in the way of litigants who are trying to get to trial. They have to plead a plausible case. They are subject. In 1986, we had the Supreme Court summary judgment trilogy, which, of course, made it very easy for the judges to throw out cases and deny trials if they didn't find that the plaintiff's claims were plausible. And then there was the Supreme Court fell in love with arbitration. So every time you get close to an agreement that mentions the word arbitration, whether you agree to it or not, in fact, you are forced to go to arbitration.
Well, they're shutting the doors of the courthouse.
Absolutely. I mean, that's correct. And even when the doors are open to get in court, getting into the actual courtroom and trying a case it's more and more difficult. So there are a lot of reasons. People say that one reason is that the fact that we have discovery, that the civil rules allow for discovery, and today, because you can find out the facts of your case without actually going to trial, good lawyers know whether they have a good case or bad case before they go to trial. They have jury consultants advising them on the probable outcome, and there's no necessity anymore to go to trial. Judges will say that they can't find lawyers who know how to try jury trials anymore. So there are no lawyers that want to go to trial. They just want to get out of Dodge, charged by the hour. And so there are many, many, many reasons why trials are disappearing. And what we found out also by doing a survey of non-lawyers in this country is 80% of the non-lawyers in this country think that in the last 10 years, the number of trials have either remained constant or increased. No one understands. Dead wrong. And they're dead wrong because they have been brainwashed by the Business Roundtable, the Chamber of Commerce, the Federalist Society, to think that this litigation explosion is still going on.
Well, Steve, this is Ralph Nader. Talk about why we should care and what can be done about it, which are your 2 points that have characterized your civil jury project at New York University Law School.
Yeah, why we should care is to think, first you have to understand why the Founding Fathers thought jury trials were so important that it's mentioned 5 times in our founding documents, in the Declaration of Independence, in Article 3 of the Constitution, and in 3 of the Bill of Rights. No other right has that prominence. And it was prominent then for the same reason it should be prominent now. The Founding Fathers feared an overreaching, powerful federal government, and they thought a jury of average citizens was a way to protect people from being deprived of their property or their liberty or their reputation by a monarch. At the time it was King George, who appointed judges, demanded loyalty from the judges, and instructed the judges on what to do. Sound familiar?
Yeah.
With our current situation in this country? Very familiar. So the truth of the matter, and that's why, and also at the time, the people who wanted a Seventh Amendment were people who were fearful of this federal government, and they also wanted juries to protect the little guy, the debtor, from creditors. And so they knew that juries sometimes would not throw people into jail because they couldn't pay their debts. All for the same reason we need jury trials today. That's why we should care. And because a jury stands between us and corrupt judges or judges who owe something to the people that elect them. Remember, 90% of the judges in the country are elected today, most of those on a partisan basis. And the federal judges that are appointed are becoming more and more either right or left. They're more extreme than they've ever been before, and many of them know nothing about trials or juries. So we need juries today for sure. What can be done about it? I am convinced that what can be done about it is getting judges, embarrassing judges, for not trying cases. And what we have been doing, like yesterday I was in Dallas, Texas, and I appeared. We have gone around the country putting on these jury improvement lunches. And a jury improvement lunch is where we invite people who have been recently discharged from jury duty and judges to come to a luncheon. We've now held 20 of these around the country. Yesterday we held the third one in Dallas, and the week before we held one in Columbus, Cleveland, and Baltimore. And we go around and we get state and federal judges to invite people who have served on juries to come to the lunch. We honor them. We put them on a panel. We ask them what they like, what they didn't like, how can it be improved. And so part of it is just talking about juries, as I'm doing right now.
Steve Sussman, this is extraordinarily fundamental. Have you gotten on NPR, PBS, or any of the national media about your National Civil Jury Project at NYU?
Nope, not yet.
Well,
I have it.
Yeah, this is what our listeners should do. You call up and you demand that this important heritage in our constitutional history get some face time and some listening time on these radio and TV stations. We're running out of time, Steve. Rick Newman, any additional questions? I'm sure you have many of Steve Sussman. But
yeah, I could talk about this for an hour. But, Steve, is there a website you would like to invite visitors to go check out or listeners to listen to or look at?
Yes. If you've been on the jury recently or receive a summons, go to a website called WeThePeopleWeTheJury.com. And that's for people who have received a summons and are looking for a way to get out of jury duty. What you're going to see when you go there are former jurors who say, don't throw away your summons. You would miss the best experience of your life. And it's also for people who have recently served on a jury to answer a questionnaire. And we've had hundreds going to this website. So that's the best place to go, WeThePeopleWeTheJury.com. The Civil Jury Project at NYU is another website, but that's mainly for lawyers and judges and jury consultants who are in the dispute resolution business. And it's quite a full website. And if you went to that website, you can see a video. We tape every one of these jury improvement lunches, which we've had around the country. So there are 20 programs you can watch where questions are put to former jurors about their experience.
Thank you very much, Steve Sussman. You know, listeners, this is the struggle between the rule of law or the rule of brute power and brute force. And I think I know, and I think Steve Sussman and Rick Newman knows, where the vast majority of the American people, whether they're conservatives, liberals, or what have you, where they stand on this issue. And thank you for your leadership. And I'm going to try to get more media for this project of yours,
Great.
Steve
Thanks
Sussman.
a lot, Ralph. I appreciate that. Nice talking to you.
Thank you.
Thank you.
We've been speaking to super lawyer Stephen Sussman, Executive Director of the Civil Jury Project at NYU. We will link to those websites he just mentioned at RalphNaderRadioHour.com. We are celebrating Law Day here at the Ralph Nader Radio Hour and breaking down the myth of the litigious society, when in fact, as our guests have mentioned, the doors of the courthouse are actually closing. Now, I did a little research on our next guest, and it is one of the most impressive and longest resumes I have ever read. A couple years ago, he joined us as part of Ralph's Breaking Through Power conference. David?
Shanin Specter has obtained more than 200 jury verdicts and settlements, each one in excess of $1 million, including 16 verdicts greater than $10 million. Mr. Specter waged an epic battle against the Ford Motor Company on behalf of the family of Walter White, a 3-year-old boy who was run over and killed when the parking brake in his father's Ford 350 spontaneously disengaged. Mr. Specter won 2 verdicts in White v. Ford for $153 million and $52 million and continued to litigate the case to a settlement. His efforts were chronicled in the book Bad Break. Welcome back to the Ralph Nader Radio Hour, Shanin Specter.
Well, thank you. Great to be here.
Yes, indeed, Shanin Specter. The reason why we've invited you on is because you have what I call a 360-degree law firm. You not only bring cases on behalf of wrongfully injured people against large corporations, you also disclose the information to alert a large number of people who might be exposed to the same hazard. You ask regulatory agencies to do their job and establish standards of safety. You also have turned a lot of your cases over to independent reporters so they can write books and articles on them for further public education. And you have taught tort law as an instrument of change at University of Pennsylvania Law School, Stanford University Law School, and University of California, Berkeley Law School. That's what I mean. You take it full circle. Now, let me ask you a question. Why is it that more large and successful law firms do not take it full circle? Because it's not enough just to bring a case or two, because we know that there are huge numbers of wrongfully injured people who never use the civil justice system, that tort law is grossly underutilized. And one reason is because the insurance company and tortfeasor lobby have propagandized people into thinking that it's somehow un-American to have their day in court against their perpetrators. Why do you think more law firms of substantial size have not followed the kind of full service to the public that you have?
Well, Ralph, thank you, first of all, for that wonderful introduction and for your question. Before answering it, may I say that you are my hero. And when I am in a courtroom litigating against the Ford Motor Company or other big corporations, or thinking about achieving structural reform with a defendant in a personal injury suit, I am simply channeling Ralph Nader. I'm channeling what you pioneered as a younger lawyer some time ago. I won't say how long ago. And you are an inspiration not only to me, but to trial lawyers across the country. And your contributions to American life are without parallel. So it's just an honor to speak with you about these issues today. And it's to my great benefit that I've been able to follow in your footsteps.
Well, thank you very much, Shanin Specter. But as you know, I'm not just interested in inspiration. I'm interested in perspiration, the kind that you exert.
I know, Ralph, but this is a race gesti. This is something I cannot help but say when I'm in your presence. So you're just going to have to forgive me for saying that.
No, thank
you. Let me answer your question directly. Your question again is, why don't more lawyers pursue remediation, not just money damages? And the reason for that is rooted in the fact that under the American system of justice, in a tort action, with very few exceptions, we are not allowed to seek an equitable remedy. We're only allowed to seek money damages. And that's the structure under which we lawyers operate. And that produces in lawyers a mindset that, well, it's a lawsuit for money damages. And if we get our client fairly compensated, that's what we were hired to do. That's what the law allows. And that's that. And so it takes some doing to reorient the minds of American trial lawyers to the fact that we can actually do quite a bit more. Because while the law does not permit us to seek an equitable relief, the reality of the litigation is that if we demand that the defendant reform itself as a condition of settlement, the defendant will often do so. And the reasons they will do that are, number one, most defendants, they don't want to act unsafely. They don't want to have, just as an example, a defective sidewalk or have a poor hospital policy or procedure or sell a defective product. They want to have themselves associated with safety and with care. Their insurance companies feel the same way. Their lawyers feel that way. Now, on some occasions, it's not possible to achieve a remedy that's equitable because the defendants feel too strongly about the safety of their product. You have, for example, transvaginal mesh, a matter that I'm litigating right now. In many of those situations, the companies believe strongly that their product is safe, and while they've taken off some of those products from the market, other transvaginal mesh products remain, and we just simply can't expect, as a condition of settling any individual case, that they're going to take that product off the market. But we've had great success in convincing hospitals, in convincing other types of corporations, in convincing governmental entities, whether it's the police department of the city of Philadelphia or other governmental entities, to reform themselves. You can go to the Klein and Specter website and read about those achievements. You can go to the website of the Inner Circle of Advocates and read about the achievements of our firm and other firms around the country where they've done that. You can go to the Tort Museum that Ralph, you and Richard founded in Connecticut and read about many of those successes. But we need to do more in that regard. And part of it is in teaching law students about the ability to go ahead and ask for and demand these types of remedies. One thing you did not mention in your very nice description of my work is that I taught first-year torts this past academic year at UC Hastings College of the Law in San Francisco. And I talked a lot about doing exactly what I've just described to you, and found several of my students who had had it in mind to go do something else with their careers have decided to become tort lawyers to achieve societal change, not just to put money in the pocket of their clients and themselves and their firms, but to get the kind of reform that I've described with you today.
And your prospectus for teaching these courses is available to any law professor or lawyer who wants to do it at any of the 210 law schools in the country. Is that correct?
Absolutely.
Could you give the website for that, Mr. Specter?
Well, again, if you go on to my firm website, Klein and Specter, you can contact me or access information about my courses.
That's KLINE and SPECTER.
Yes, sir.
Rick, I'm sure you're wanting to ask Mr. Specter more than a few questions, but what are some of the important ones you want to put before him?
Well, we've been talking to some extent earlier with Steve Sussman and in my earlier remarks about how the tort system has been under attack with limiting access to court, caps on damages, the psychological warfare about people buying into the myth of frivolous lawsuits. How has that impacted your practice, or how does it impact your practice?
Oh, it's an awful problem, Rick. The truth of the matter is that we trial lawyers have done a terrible job of convincing Americans about the importance of what we do. The blather of the insurance industry and of the Business Roundtable about jackpot justice and lawsuits being a lottery and the like have permeated the consciousness of many prospective jurors. And what we need to do as trial lawyers is we need to vigorously and assiduously educate the public on what we do. Mm-hmm. And that means, for example, when we get a reform in a case, such as the kind we've talked about today, we have to do our best to have that reform not be the subject of confidentiality. And we have to broadcast that. We have to tell the news media about it, both the legal publications, but more importantly, the publications of general circulation. We need to tell it to the television stations. We need to write books and articles about what we're doing. Our firm has been the subject of 5 books about our practice, and they've gained, I think, pretty impressive circulation, including as part of college curricula and law school curricula.
And sold here, by the way, at our museum store. Yeah.
Well, thank you. Well, thank you for that.
Well, you're exactly right. Public education is critical to changing the shape of this dialogue.
One of the problems is that, look, nobody thinks they're ever going to be the victim of a tort. People think, well, I act carefully. I mean, I wear my seatbelt. And, you know, I look both ways when I cross the street. Nothing bad's going to happen to me. And people don't know that, well, with respect to, for example, being in your car, you can be injured by somebody else, not just yourself.
Right.
Or you can be in a vehicle that's defectively designed or manufactured. And just ask Ralph Nader about unsafe at any speed, where just wearing the seatbelt isn't going to protect you. And so everyone in this country needs a vigorous tort system. They need a tort system that's not manacled by caps and immunities, for example, where you can hire a lawyer and a lawyer can seek justice for you in a courtroom unfettered by some one-size-fits-all.
Well, Rick and I have proposed, Arlen Specter, a National Tort Law Education Day, like on May 1st of every year, where all the trial lawyers and law schools and others engage in a public information campaign. They can even have debates with defense lawyers. They can talk about jury trials and our founding fathers. They can talk about the gross underutilization by wrongfully injured people or their next of kin of this law of torts that's available for them to use and to have their day in court. The Johns Hopkins University School of Medicine people came out with a report about 2 years ago that said that at a minimum, 250,000 people in this country die because of preventable problems in hospitals around the country. That's about 5,000 a week. And only a tiny fraction of the next of kin out of that 250,000 ever go see a lawyer. How can we remedy that?
Well, Ralph, you're raising a lot of very important concepts at once. And look, every day for me is Tort Education Day. whether it be with my law students or with my clients or people in my firm or the bar generally or the general public. This is what I've devoted my practice to. And I think we've got a winning argument, and I think we will win. I think we will overcome this problem that's been foisted upon us by the defense interests because we are so plainly and clearly right. And I'll tell you, another ray of sunshine in all this is that we have found terrific success in the past several years in trying our cases in very, very conservative venues. Just as examples, in Pennsylvania, we have some very, very red counties and red federal districts as a result of a shifting of political voting patterns, particularly with respect to the last presidential election. And we've gotten excellent results. Well, why is that? We've gotten good results because we bring them meritorious cases that are honestly presented. And people are willing to be fair-minded. If you can strip away in jury selection the people that hate the tort system, if we're given the right to ask some questions in jury selection, which we are in Pennsylvania, and get people who can be fair, they will treat our clients fairly. So I feel that the future is bright. I'm optimistic.
Do you think it's a good idea to have one National Education Day, Tort Law
on
Day?
That one question, of course I do. I just don't think it ought to be May 1st because that was yesterday. And I don't want to wait 364 days for it.
Touche. Rick, another question?
No, I think that's good. It's encouraging to hear that there still is residual faith in the jury system. We've had that when we have tours here. People take pride in the fact that the Constitution and the Bill of Rights ensure the right of trial by jury. And the people who have served on juries, both when I was practicing and when I interview people at the museum here now, people who served as jurors think it is one of the most wonderful, powerful, best things they've ever done. Has that been your experience?
Absolutely. People are unhappy when they get a jury summons and they don't like showing up on the morning of jury selection, but if they're selected once they get into the trial, they show up early and don't take a long lunch break. I mean, they're just delighted to be in the courtroom and to deal with an important matter that they have to resolve for the benefit of the community.
Yeah,
and I've seen that uniformly. Uniformly, jurors who get on the jury, for example, they might have a personal issue in their lives. They might have a scheduled vacation or something comes up within their family. They'll put aside those personal issues just to stay on the jury and not have the case be decided by the alternates.
Yes.
So, yeah, it's amazing how people feel so strongly about the jury system once they live it themselves.
Right.
We've got a lot of work to do, and we have people who are transformed by their experience at the museum going out, and they're their own tribunes, and they really talk about it to their friends and neighbors. But obviously we need more. We need NPR and PBS to put more time on the civil jury trial crisis in this country, and the other media ought to start standing up for these important subjects and not be so addicted to tons and tons of hours on entertainment and sports only. I might note in passing that Shanin Specter is the son of the late U.S. Senator from Pennsylvania, Arlen Specter, who was one of the lone Republicans to stand up against the Republican Party when the Republican Party wanted to ram through Congress restrictions on your right, American people, to have your day in court by trial by jury. Thank you very much, Shanin.
Thank you very much, Ralph, for calling my father, and thank you for this interview today.
To be continued. Thank you again.
We've been speaking to legendary trial attorney Shanin Specter, who talked about how it's not always about winning the money. It's also about fixing a larger problem to protect those in the future. We will link to his website at ralphnaderradiohour.com. All right. We have some time for listener questions, and we got a few really good ones. David, why don't you do the honors on the first?
This one comes from Alex Nunez. It's about corporate welfare. He writes, Ralph's home state of Connecticut is very close to approving a more than $100 million subsidy package to a subsidiary of defense contractor General Dynamics. He goes on to write, Connecticut has had widely reported financial issues in recent years that has made steep cuts to public services to fill its budget holes. Despite that, it's willing to give a massive deal to a company that builds doomsday weapons. Ralph?
Well, it is official now. On May 1st, Governor Malloy announced what he called a historic long-term partnership with General Dynamics, which builds these giant Trident and other nuclear submarines near New London in Connecticut. I'm looking at this press release with almost utter amazement. Why are Connecticut taxpayers being required to subsidize a monopolistic military manufacturer of nuclear submarines that is given billions of dollars from the Pentagon, paid for by the federal taxpayer? Connecticut is unfortunately experiencing crumbling infrastructure and public works. It has huge budget deficits, and yet this governor has been allowing himself to be extorted by some threat by General Dynamics to move its base and its employees elsewhere. They're not going elsewhere. They've been at the Groton base for decades. And so we have a new chapter in corporate welfare or crony capitalism. Not only are you required to fund football stadiums and baseball stadiums, taxpayers, or other companies in the civilian area with your tax dollars, you're also now beginning to be required to fund a locked-in Pentagon military contract, which by definition is profitable. It's built right into the contract. And so, once again, autocracy reigns. I don't recall any hearings by the state legislature in Hartford hashing this out and giving people who are critical of this deal a voice. I would urge you, Mr. Nunes, to file a Freedom of Information request to the governor to get the copy of this agreement, which he will not be able to withhold, and spread it around your area. And I hope listeners will do the same from the state of Connecticut, because it's quite clear that now the other defense contractors around the country, Lockheed Martin, Boeing, Raytheon, are going to try to pull off the same deal, get the government contract from the Pentagon's bloated budget, and then make you, the taxpayer, including diverting some of your sales taxes, to further subsidize these mega manufacturers of weapons of mass destruction, who are already making staggering profits with skyrocketing stock prices on the New York Stock Exchange.
Ralph, you told Mr. Nunes to file a Freedom of Information Act request, and that sounds great. And if you told me to do that, I'd go, yeah. And then I'd go, wow. How does he do that? How does a person not used to doing these kind of things like you are file a Freedom of Information Act request?
It's actually very simple. We teach it to high school students.
Well, that's above my head already.
Yeah. Okay. It's actually
so dumb it down a little.
It's actually very simple, Steve. Have listeners go to citizen.org and then go to the Freedom of Information Clearinghouse of Public Citizen, and there's a how-to online that will answer your question. It's quite simple.
Was the Freedom of Information Act your idea?
We were the principal lobbyist for the federal Freedom of Information Act in 1974, the best in the world, and then the states started enacting their own state Freedom of Information Acts in subsequent years, yes.
All right. Well, thank you for your question, Alex. Our next question comes from Saul Zohari, I believe his name is, and he was listening to our show about Syria with Joshua Landis, and he's, I'm going to warn you, Ralph, he's not too happy. He says, I listened to your radio hour with Joshua Landis, who you introduced as a, quote, Middle East expert. And he says, I did not see anything in his words that indicated a sign of intelligence about affairs in the Levant. And he tries not to use the term Middle East, as it is an invented word by colonialists. And he says, bringing a guest like that seriously damages your program's reputation. I do not see any truth in your guest's words except praise for colonials and their lackeys. I am curious why he uses the term regime for the sovereign Syrian government, but does not use the same term regime for Saudis, Israelis, etc. Regards, Saul. What do you have to say about that, Ralph?
Well, Saul, first of all, we usually bring advocates on the program. He is not an advocate for one side or another. He's an academic out of Oklahoma. He has what is generally believed to be the best factual website on the situation in Syria. And his website is joshualandis.com. JOSHUALANDIS.com. And Saul, you can decide for yourself how accurate the information is. He doesn't take sides in this multiplex civil war. But if you listen to the interview again, you'll note that he went through not just what's going on in Syria, but he went through some of the clearly aggressive behaviors by the U.S. historically over there, just as a matter of fact. But he does have to be very careful and not say he's on one side or another. And I can see that you know that there are certain equities and inequities in that imbroglio over there, and you were probably looking for somebody to take sides. But he's an academic, but I've had a lot of people who are very progressive who think that website is the go-to website to try to understand the parties that are involved, who's backing them, and what's going on in Syria. JoshuaLandis.com, and you can go to the Syria comment section on that website.
All right. Thank you very much for that question, Saul.
The next question, Ralph, comes from Earl Ammerman IV. He writes, Ralph, are super PACs breaking election law when they directly coordinate with a candidate?
Definitely. Federal election law allows these super PACs to give all kinds of money for or against candidates for elective office, as long as they don't coordinate with the candidates they are supporting. And unfortunately, the Federal Election Commission, which is a toothless enforcement agency because it's split, 3 commissioners are Republicans, 3 are Democrats, and guess what? They deadlock and nothing gets done. And so increasingly in recent years, these super PACs have associated with the candidates, sometimes actually on the same stage, and they've gotten away with it. But it's clearly a violation of federal law. They're not supposed to be in touch with them, communicating with them, strategizing with them, and increasingly those restrictions are being widely violated by these arrogant PACs because there's no federal cop on the electoral rule beat.
And he talks about on April 28th, which was not that long ago, how Trump held a 2020 campaign rally in Michigan and Corey Lewandowski made a cameo appearance. And if Corey Lewandowski works on his PAC, that's like a direct violation, right?
That's right. And that is being investigated. But then they had the Federal Election Commission, which we're quite familiar with in our campaigns. They say they're going to investigate, and then months, sometimes years go by and nothing happens. That's why some people have called for the abolition of the FEC, which stands for the Federal Election Commission, or at least, appoint a neutral commissioner so it isn't just a deadlock 3-3.
Right. All right, Ralph, this question comes from a listener, Doug Sasser, and he says, it's another tough one. We take on the tough questions here. He says, Ralph was critical of Bill Gates and his charitable work through his foundation. He has praised the charity work of Ted Turner in the past. How does Ralph decide which millionaires to praise?
Well, it depends on what they're supporting, obviously. I have no favorites or non-favorites. I praise Ted Turner because he gave $1 billion over time to the United Nations Good Works, and he spent time with people at the United Nations to make sure that that money is steered into good charitable, essential educational peace works around the world. Also, Ted Turner has been in the forefront of warning about proliferation of nuclear weapons, about the need for abolishing nuclear weapons, about the need for waging peace. That's pretty unique for a multi-billionaire. Bill Gates has worked in the area of infectious diseases, and some things he's done have been very good. They've prodded U.S. and other governments to put more money into the area of malaria and tuberculosis and other infectious diseases. On the other hand, he's supported educational moves that have helped the charter school movement, which I think is unaccountable and highly exaggerated in terms of its benefits, even though it tends to cream off the crop and doesn't take the more difficult students. And, that's quite controversial. I don't think he's done it right. I think he would have done a lot better if he spread the education for civic skills and experience in high schools and middle schools all over the country. That would have been very good for future leadership and a stronger democracy.
Shouldn't Bill Gates and Warren Buffett, who is turning his entire fortune over to Bill Gates to give out in terms of charity. Shouldn't they be paying taxes instead? They're acting unilaterally. Is it up to Bill Gates to decide how these billions should be spent without consulting our democratic institutions? Isn't the National Institute of Health entitled to say how this money should be spent? He should be paying his fair share of taxes instead, don't you think?
As you know, they can give huge sums to a 501c3, which is the Gates Foundation, and deduct it over a period of years from his enormous other income that he gets from Microsoft and other investments. Yeah, there have been articles written. Have these foundations become too powerful, too able to extend their impact and decide how public funds are going to be used for research or development in the various fields that these philanthropies are in? Although Warren Buffett has contributed over $30 billion in the last 10 years, imagine that, to the Gates Foundation. He is on the board with Bill and Melinda Gates, but he lets them do the decision-making. He doesn't sway it either way. I wish he would, because he might have gotten the Gates Foundation to deal with tax reform, David, which is one of his prized priorities, because he thinks, talking about Warren Buffett, that there should be more progressive taxation of wealthy people.
Well, thank you for your questions, listeners. They were some tough ones, and we don't shy away from that here. Keep them coming either on Ralph's Facebook page or on the Ralph Nader Radio Hour website or on the Ralph Nader Radio Hour Facebook page. I want to thank our Law Day guests again, Richard Newman, Executive Director of the American Museum of Tort Law, as well as super lawyers Shanin, Specter, and Stephen Sussman. For those of you listening on the radio, that's our show. For you podcast listeners, stay tuned for some bonus material we call The Wrap-Up.
For Ralph's weekly column, go to nader.org. For more from Russell Mokhiber, go to corporatecrimereporter.com.
Visit the American Museum of Tort Law and go to tortmuseum.org and check out the Tort Museum bookstore for engrossing books and memorabilia.
Join us next week. Thank you, Ralph.
Thank you, David. Thank you, Steve and Jimmy. And to our listeners, we're gaining more radio stations from Minneapolis to Washington, D.C. You can help us in your area by urging your radio stations to carry this program. It's not exactly redundant, is it, with other commercial and public radio programs around the country?
Hi, this is Jimmy Leewert, producer of the Ralph Nader Radio Hour. Welcome to the wrap-up, where Ralph weighs in on Michelle Wolf's performance at the White House Correspondents' Dinner.
Did you hear the Correspondents' Dinner speech by Michelle Wolf?
Yeah, I've been reading some of the commentary. First of all, I think they deserved it.
Oh, yeah.
First of all, they knew what they were getting. They weren't blindsided. Second, they deserved it. They're part of the clique there.
Yeah, it really exposed them as, everybody with all of these hurt feelings and how supposedly raunchy she was.
Yeah, what about, as they said, what about Trump?
Yeah.
Verbally and behaviorally. You're not dealing with an ordinary president. You're dealing with someone who needs to take it and doesn't want to take it.
Oh, yeah. And, and they falsely accused her of making fun of how Sarah Sanders looks, which she did not at all.
Well,
how?
Some of the references to the Handmaid's Tale.
But that's not a
the softball team. There was a softball team joke that was borderline lesbian.
Really? I didn't read that one. I didn't.
Yeah. Choosing up sides for a softball team.
Who was the lesbian?
Well, she was saying that Sarah Huckabee Sanders looks like she should be choosing up sides for a softball team, which softball is a buzzword for lesbians.
David, you really are au courant. Even Steve didn't know that one.
I play softball, David.
Okay.
This is hilarious.
And then Steve asked Ralph a very ominous question.
So you think we are seriously threatened by the idea that in order to distract from all of this investigation stuff, he might be willing to take us to the brink of war with Iran?
Oh, yeah, sure. In fact, we're working on a full-page ad in the New York Times called Stop Trump Before He Gets Us Into a War. Henry Jarecki's proposal, and then publish it in newspapers around the country.
Wow.
Oh, yeah. I mean, it's automatic, right? I mean, this guy's got the perfect instinct for that.
Well, 9/11 saved the moribund Bush presidency.
Sure. No, we are now able, our entire democratic heritage and institutions can be flipped by 5 people in Washington. Flipped. And, all these corporations that are going to pay a price for that, too, when the stock market collapses and everything. They're sitting on their ass, too, doing nothing. You get someone like Paul Volcker picking up the phone. I mean, he knows people who are, Robert Rubin, so on. They're all, they don't either care or they're part of the neocons. Look, it's just what David referred to earlier. David, it's 1930 Germany.
Wow.
In other words, it's Edmund Burke. All that's needed for evil men to prevail is for enough good men not to care.
Yeah.
Was that Edmund Burke? Was he about the French Revolution?
I know it was the American Revolution. That's when he did it. That was his period. And, the thing is that, like, everyone at least can pick up the phone and call their senators and representatives, for heaven's sake. Congress is dead in the water because they're not hearing anything from back home. I mean, I'm told by senators and representatives, we're not hearing about this. I said, you don't have to hear about it. You've got the authority and the duty under the Constitution to stop it. So wars are not being declared.
Well, they have completely abdicated their responsibility for war making.
Right. And having said that, the burden shifts to us, right?
Yeah.
That's what it shifts to.
Crazy.
Call Schumer, David.
Yes.
Chuck Schumer, not Amy.
And that's a wrap. Tune in next week.